Hello, hello, hello. This is Attorney Mike Revlin coming to you from Chicago. As usual, I've got kind of a strange, interesting one today. We've got a sentencing that's pretty sad. I know we have lots of animal lovers in the group. This is going to make you angry. It's a little bit of a trigger warning, but it's also interesting. It's bad. I feel bad for everybody involved. And I just thought I'd tell you that ahead of time. You're also in danger of learning something here. There's some top-notch advocacy, in my opinion. Also, the judge handles it very well, but he goes through his reasoning on the record, so you can really see this whole thing play out. But prior to that, I have a couple little clips. We've got a little update on Mr. Bloom. Is Mr. Bloom behaving himself? I think we know. I think we know the answer to that question. We also have a guy who can't stop talking about his case. Just a little warm up before we get into the serious stuff. Let's do it, shall we?
All right, you have one charge. It's a Class A misdemeanor assault causing bodily injury involving family violence. The range of punishment for this, if you're found guilty, is a fine not to exceed $4,000 and a jail term not to exceed 1 year or both. Your bail is set at $5,000. An emergency protection order has been issued that we need to go over. Do you want to see if you qualify for a court-appointed lawyer, or do you plan to hire a lawyer?
Court-appointed.
All right. Regarding the personal bond, we haven't been able to reach the complaining witness in this case to see what their position is on a personal bond. So I don't feel comfortable signing one at this point. If you're not able to post bond, you'd probably have to come up with about $500 or so. If you're not able to post bond to get out, then you can talk to your lawyer about seeing, you can still try to get a personal bond or getting the bail reduced to an amount that you could pay. But let me go over this emergency protection order with you. This is for the protection of Jose Ramirez. You're prohibited from committing family violence or an assault or any type of stalking or trafficking offense against him. You're prohibited from communicating directly with him in a threatening or harassing manner or communicating a threat through someone else to him. And you're prohibited from going within...
Don't worry, this gets worse as soon as he starts talking.
200 yards of Zurich Drive in Del Valle, Texas. You prohibited from possessing a firearm, and a violation of this emergency protection order could result in a new charge. And this is in effect until 11:59 p.m. on September 20th, 2023, which is about 2 months from now. So do you have any questions?
No, ma'am. I'm just ready to leave that house. The man has been harassing me and threatening me for the last 4 years, and everything just built up, and I just let it go.
Yeah. Stop talking about your case, please.
He has been threatening me and harassing me, and I can't eat food at the house. I can't drink water at the house while him looking at me real mean, while him talking crap to me.
Okay.
While him threatening me. So it was nothing I could do. This was just a whole bunch of buildup that led to just...
Okay. Well, I don't want you to say anything.
Oh, no, I'm guilty. I'm guilty as charged. I'm guilty, man.
Don't say anything.
No, I'm guilty. No, I'm guilty. I'm guilty. I'm guilty as charged. The Lord is my witness. But I wanted to be on file. I wanted to be on file that he has been harassing and threatening me for the last 4 years.
Hey, stop talking.
All right, you
Bear in mind, this is a family member that probably won't cooperate with the prosecution. So if you shut your hole, you probably don't get convicted.
You can talk to your lawyer about that, and your lawyer can help you with that. And if there's any of the situation where that information is helpful, your lawyer can use that to your benefit. Okay.
Yes, ma'am.
All right. Thank you.
I just wanted that to be on file.
Yes, yeah.
It is.
Come on.
Oh, that's it?
That's it.
Yes,
Okay.
sir. Thank
Well,
you.
you have a good day.
Thank you, Sammy.
What? Couldn't say anything.
My apologies. Laptop died.
Area
Jeff's here.
people.
Okay, good afternoon, Mr. Bloom.
Good afternoon.
I have your new attorney, Mr. Ballard here, and since he has just been appointed as your attorney,
Yes, when we last saw Mr. Bloom, he was busy getting rid of a perfectly good and competent attorney. Seems as though he's gotten another one, but well, let's see.
he needs to get the discovery in the case from your prior attorney and get ready. So it appears that he will not be ready for the jury trial date you previously had, August 21st. Is that correct, Mr. Ballard?
Yes, Your Honor, the court is correct in its assessment.
Okay, and I did explain to counsel, Mr. Bloom, that we're transferring case assignments here, and your case and the rest of my criminal docket will be heard by Judge Slay. So we could adjourn this pretrial to August 17th.
I'm feeling a Kelly Messenger Bloom back-to-back extravaganza over in front of Judge Slay.
Which would give Mr. Ballard a chance to get the discovery and have someone presumably talking with you before that day. Is that correct, Mr. Ballard?
That is, Your Honor, again, the court is correct.
And Ms. Reiser, you had no objection to adjourning to August 17th?
No objection, Your Honor.
Okay, so is there anything further that we can accomplish today, counsel?
I don't believe so, Your Honor. This, like I said, this is my first opportunity to come in contact with Mr. Bloom. I will be making it to Washtenaw early part of next week to meet with him.
Anything further, Ms. Reiser?
No, Your Honor, the trial will be canceled for the 21st and we'll be back before Judge Slay on August 17th at 1:30. Thank you.
Your Honor,
Trial is canceled. Yes, Mr. Bloom.
I need like 5 minutes like I did last time to just address the court with something that I need on record.
Well, no, because I don't know what you're about to say,
It's
and I
not got
want
anything to do
attorney
with
to have, I want your attorney to have the opportunity to talk with you first.
I do not
So-
have transcripts. I do not have transcripts, Your Honor. That's what I'm
Okay.
saying. I don't have transcripts.
That's something you need to talk with your attorney about. Thank you.
Good day.
Thank you,
too.
Judge.
You're welcome.
That concludes our docket for today.
Boy, I'm just getting railroaded here.
We are next taking up the case of the people of
Okay, gird yourselves. This is a tough one, but it's interesting.
the state of Michigan versus Thomas William Middow. This is file 23-13532 FH. Appearances from counsel, please.
Good morning, Your Honor. Corey Williams on behalf of the people. May it please the court, Robert Champion appearing on behalf of Mr. Middow, who is standing to my left here.
All right, thank you very much. Sir, you may be seated. And the court recognizes Mr. Stephen Salome, an agent from the Michigan Department of Corrections, to offer the pre-sentence investigation report. I see some letters being handed out or exchanged between counsel, or is there anything to add, Mr. Champion, that I can look at before I begin?
Yes, Your Honor.
All right,
It
thank you.
is a counseling record for the court.
Thank you. The court is receiving those records, and I won't make them an attachment to the pre-sentence investigation report. I see that Mr. Wiggins has a copy. Mr. Wiggins, do you have any objection to the court considering this content?
I do not, Your Honor.
The court finds it appropriate for consideration and read the court rules and statutes for sentencing. One moment as I take a look at it. All right, the court has read through that document. Now I'll turn back to my typical proceeding. Mr. Wiggins, have you gone over that pre-sentence investigation report And if so, do you have the amendments, corrections, or objections?
Well, we're at sentencing, but I get your point. And yeah, defendant wouldn't want any of this chat on a jury. That would not go well.
Make certain.
Your Honor, I have received a copy of it. I reviewed it and I have no additions or corrections.
Thank you. I also reviewed it and I did not notice any need for change or any challenge to the scoring, at least on behalf of the court. Mr. Champion?
Yeah, other than the document that I provided the court, we have no additions, corrections, or deletions.
Before I turn to allocution, Mr. Wiggins, I think somebody told me, or at least it was referenced in here, that somebody wishes to make a victim impact statement.
Yes, Your Honor, I believe Ms. Samantha Old would like to address it.
Okay. Ms. Olds, you may come forward and you may take this podium right here. All right, Ms. Olds, is it Samantha?
Yes.
Common spelling?
What was that?
Common spelling?
Yes.
And Ms. Olds, common spelling?
Yes.
Thank you, ma'am. You may speak.
I just want to thank anybody that came out here today and support for us. This is such a hard thing to talk about. This situation with Bear is so beyond heartbreaking for our family, and it could have been totally avoided if there had just been any communication that our dog had been over to his property. We have a 55-acre farm. We don't ever have problems with him leaving it. So as far as leashing him up outside, he's a farm dog. We don't generally do that. He never usually leaves the property, and we followed his tracks that one night when we noticed he wasn't around after an hour or so. And luckily there was snow, so we could see which direction he went, which it was odd that he even went that direction. So we followed those tracks, and it led right to Mr. Middall's yard, where we found blood and his tracks going into his yard. So fast forward the next day, we had called the officer to come investigate, and he had admitted to shooting Bear and that he's no longer in one piece. I'm not sure what his claim was for the dismemberment, but that is just something that we can't unsee ever. The box that we received him in was a dirty cardboard box, and Bear was wrapped in garbage bags, and the box was like I could fit in the box. It was so big. So there was no need to dismember him to fit him into that box, but we had to take him out to bury him because the ground was partially frozen. So unboxing Bear's body is something that we can't unsee. He's like a child to us, and we had to pull his blood-soaked head that was off of his body out of that box, and it's just something we can't outlive in our memory. And it may not impact some people the way that it does us, but we celebrate our dog's birthdays. They're our best friends, and it's comparable to a child for us. And if it's okay for people to get away with that, it makes me scared for what else they're capable of. It makes me nervous for my child, since he lives so close to us. Other kids down the road, even his children, I don't know what kind of relationship that holds, but it's just a worry to the community in general, and it would be devastating if there wasn't any real consequence for what he did.
Thank you, Ms. Holtz. Thank you. October 10th, by the way. That's the date Hobie Elmore, our dog, was born. You may return to your seat. Thank you. Mr. Wiggins, anything further? Any other victim impact statements?
No, Your Honor.
All right, thank you. I turn back now to Mr. Champion.
Yeah, and I hate to turn the tables on this case, but I have to make some things correct.
Mr. Champion, your defense counsel. Go
I'm
ahead.
looking at the report, and this is quote from the owner of the dog, said that this dog was known, and I'll quote, was known to wander the rural area from his residence and was not known to cause trouble. Well, in this particular case, this dog was 3/4 of a mile in a straight line from where it was supposed to be. We don't even know how long it had been gone. They said it disappeared possibly around 6, but it was several hours later before they noticed that this dog was missing. My client shot this dog on his property when this dog was harassing my client's dog, which was leashed up, chained, and kept on his property. The law is clear. Dogs are supposed to be either contained and they're not to trespass on other people's property. And we all know, I have a dog. You never know what they will do when they're not around. And if this dog had attacked a chicken on my client's farm, my client would have been completely within his rights to kill the dog. But the current case law,
Under current Michigan law, that's
Under
correct.
current-
If it's a pet versus
livestock. And the Court of Appeals clarified that for all parties sometime. My client feels bad about what happened. He reacted, he thought he was within his rights. He now knows it's wrong. My client is in counseling. He has endured threats to his life and his family's life for a dog that was on his property 3/4 away. He didn't know this dog. He didn't know the people. This dog was trespassing on his farm. And I hate to say it, I was raised on a farm. It is common for farmers to dispose of animals that are not theirs, that are on their property for the protection of their farm. My client's not trying to justify. He's accepted responsibility in this case. But the record should be clear. This wasn't a random act. This was an act that occurred because a dog came trespassing on his property that he did not know, and he reacted. He regrets it. He regrets the hurt that has caused the other family, but I think he has suffered enough in this case, and I would ask the court to consider fines and costs and restitution only.
I think that was a fantastic job by his attorney in a horrible circumstance. Nobody wants to get up and defend this. And I think he hit just the right point. He says it's wrong. We accept that. And then he makes, I think, a compelling argument on behalf of his client. I also think the prosecutor does a fantastic job as we proceed here.
Mr. Wiggins, I probably wasn't sensitive to looking this up before, and I don't want to be disrespectful to someone's pet. Is there a request for restitution? Mr. Champion mentioned restitution, and I don't think there was any request for it. But before I turn over to you, well, as I get ready to turn out allocation over to you, is there a request for that? I don't know.
We have not received a request.
Okay, no problem. I just, because Mr. Champion had said it and I didn't recall reading it, I wanted to make sure that I didn't gloss over that request. Pursuant to Michigan law, they would have the right, the victims would have the right to request that, but they don't always, and when it deals with a loved one, of course. So anyways, Mr. Wiggins, allocution, sir?
Thank you, Your Honor. These cases are, and I say this quite a bit, but this one truly is one that there's no good way to handle this case. The legislature, unfortunately, in dog law, is still set in the past. It does not morph into recognizing that people see their animals, particularly dogs, as members of the family. So the guidelines and scoring don't take that into account. I will say that I too want to correct the record because there is some misconception out there, and that's because the defendant was charged as a habitual offender. And I think it's important to recognize that those are based on prior felonies. They're not based on prior activities such as this.
I've heard, it's a small community. I've heard that rumor that he's had prior convictions or charges of this kind, and there's nothing inside his criminal history to suggest that anything like this has ever happened in the past.
Correct. And in fact, the majority of his prior history involves drunk driving and
Correct.
substance.
His prior felonies, which is what is, when you look at a felony information, it references as a prior habitual. What that means is that he has prior felony convictions. I understand. Go ahead.
Thank you, Your Honor. And I will also say this, I have received more emails regarding this case than any other case, including murders we've had in the county. So I realize what a hot topic this is. I realize how emotionally charged this topic is. But the truth is we're left with what we're able to sentence the defendant to. And in this case, those guidelines are 0 to 11 months. And as the court is aware, with the criminal justice reform that came through in 2021, that means there's a presumption of no jail. And we're left with looking at a probationary period unless we can find reasonable grounds to exceed that and impose a jail sentence. In this case, Your Honor, I believe the reasonable grounds would be the fact the way that bear was disposed of. I believe it is one thing to shoot an animal or shoot a dog because it's attacking another dog. And to be honest, Mr. Middall was the only one there. He's the only one that can tell us whether that was truly happening. But that's the fact that we have. And so I think what gets us to a jail sentence is the fact that he hit it, he dismembered the dog. You know, there's been some mention that he's taking responsibility.
Well, never mind, I'll make a comment. Go ahead. The fact that he hit it is already taken into consideration in the scoring, because I think there's a scoring for interference with justice, maybe. Am I right, Mr. Champion?
You are. Yes, you're correct.
I just want to make sure the defense understands I recognize that, Mr. Champion.
Thank you.
Listen.
But we still have the dismemberment, and we still have the fact that he didn't own up to what happened until such time as he was confronted by law enforcement. Your Honor, I think this case does justify a jail sentence, and I realize that no sentence that's imposed is going to make the Olds family whole. This is a terrible loss that they've suffered. And I would ask the court to impose a jail sentence. The recommendation is for an 18-month probationary period as well, Your Honor. I think in light of the defendant's history, the fact that he's in counseling now, I think goes to benefit, but I think it would be important to impose at least a 24-month probationary period in addition to a jail sentence. And I'll be honest, Your Honor, I'm struggling with what that jail sentence should be at this point, because I know what the law says versus what it's like to lose a member of the family. And as I said, we can't mash those up and make everybody whole in this. But I would request a jail sentence of at least 45 days. Your Honor.
Mr. Middall, you have the right to make a statement before the court issues a sentence. This was a guilty plea, am I correct? Yes. Exactly. You have the right to make that statement. Is there anything you wish to say at this time, sir?
I apologize for the whole situation. That's unnecessary. No, I'm sorry.
Okay. I know that this issue has garnered quite a bit of attention, and thankfully, very little of it has come to the court. Anybody who has attempted to communicate with me, it did not get read. I do not read ex parte communications. The reason is because as a judge, I need to make sure that anything I read or anything that comes into my consideration, each of these attorneys has the right to hear it, read it, and respond to it. So it's not to be rude or offensive. It's just to state that I must, as a judge, put aside any personal feelings and ensure that my rulings are based upon the law and the facts as they are appropriately presented to me, such as in the pre-sentence investigation report. I will state that there are often misperceptions or people who like to say that the law in Wexford County or Cadillac is failing them when they try to discuss this case or other cases. First, I'm going to note one thing. Any alleged violence or threat of violence against Mr. Middall is 100% unacceptable. We do not solve problems or challenges in our community by reacting with violence. We might feel those senses of anger, but to ever act on them is inappropriate. And even to threaten them is unnecessary. The way the law works in the state of Michigan changed back in 2020 When somebody scores a felony conviction, a sentence is guided by the Michigan sentencing guidelines. As a judge, I'm confined by those guidelines. Like it or not, I am governed by those guidelines that are given to me by Lansing. When somebody scores on a sentencing guideline, they can get a presumptive prison sentence. They can get a straddle cell sentence where I can choose prison or jail, or they get an intermediate sanction. An intermediate sanction might give a guideline scoring range, such as in this case, of 0 to 11 months. And the average person would think 0 to 11 months would be an appropriate sentence. Our legislature and our governor has told me that is not true. It can read 0 to 17, and as of December 2020, it became unlawful for me to give any confinement unless I find reasonable grounds. So we have to start by law with a sentence that is a probationary term and fines and costs. If you do not like it, contact your legislature because I have no control over Lansing. It is not the courts who pass this law, it's the legislators. And I don't challenge them for the reasons why they pass it. I'm just saying, when you start talking about flinging arrows, what you need to do in our respective society and our republic is to communicate with your legislators. They're the ones that change the law. Now I could find reasonable grounds. What can't I use for reasonable grounds? Because Lansing doesn't tell me, or any judge in the state, what are reasonable grounds. They do tell us, however, what are not reasonable grounds. And you've already heard some conversation between myself and counsel about what are not reasonable grounds. I cannot use anything that's already taken into consideration to score in the guidelines. For instance, there is what's called a score for an offense variable 19 for interference with the administration of justice. In this particular instance, if there was a statement to law enforcement that he didn't know where the animal was, or the animal was put into a box, that's an interference with administration of justice. I can't consider that. Let's take a little bit better look at the offense here. Now, there was a pretrial agreement reached, and that, of course, changes where the guideline ranges are. And I respect and appreciate that in this particular county, our prosecutor's office has about 1,500 cases charged in any given year. 1,500. And the most they can take to trial in this county is about 18. What do we know about the facts of this case? Bear was allowed to roam free. That's not to push the blame on the Olds, but let's be very clear about the facts. Bear was allowed to roam free, and he went onto someone else's property. Mr. Middow admitted to shooting and killing the dog. Bear. When Mr. Olds, who was an experienced hunter, tracked the dog, Bear, by looking through the snow, tracked it down to Mr. Middow's property, he then began to see a trail of blood that led him to a spot where apparently it was clear that Bear had passed away. It is clear again that Mr. Middow knowingly shot and killed Bear, and that he hid the fact and pretended to help Mr. Olds locate Bear, and then told Mr. Olds untrue statements as to when he last saw Bear. And then when the MSP trooper came around to investigate, Mr. Middow lied to the trooper. All those facts are already considered in the guidelines. The trooper found a blood in the snow and then tracked it to blood contained in a dumpster. When he asked about it, Mr. Middow did not tell the true statement. That again is already considered in the scoring of the guidelines. When pressed, Mr. Minow did admit to shooting the dog. He stated that the bear attacked his dog, which was appropriately tethered in a dog run on his property. He then went inside and got a .22. He then shot to try to scare the dog, but not shoot it. However, according to the report, he then shot the remainder rounds of the .22 and then shot bear at least 3 times, as if I recall correctly. The loss of bear itself is quite difficult. Clearly, what draws the attention to the case is what happened to bear afterward. And that's what Mr. Wiggins is focused on. And I appreciate him coming to court today and giving grounds, what he thinks could be reasonable grounds for a jail sentence. He could have come to court and just said, Judge, give him a jail sentence without establishing reasonable grounds. But clearly, I respect and appreciate Mr. Wiggins' approach to come to the court and argue what he believes to be reasonable grounds. Also, when we look at sentencing, people will often say, well, court, can't you look at the defendant's prior criminal history? The answer is to find reasonable grounds? No. Why? Because his prior criminal history is already taken into consideration in scoring of the guidelines. Again, the legislature has told this court that in scoring guidelines, the court may not consider things that in finding reasonable grounds, the court cannot consider factors already considered by the scoring. So the fact that Mr. Minow has prior criminal history, I cannot consider in establishing reasonable grounds to support any period of confinement. What can the court look at? The court often looks at, by the way, you're all more than welcome to come to court any Monday. We're always here doing sentencing, and we're open Monday through Friday, and you're all welcome to be here. The court often looks at how a defendant has behaved in the past on probation. Let's take a look at that in this instance. One moment. Mr. Saladiak forgot this. I meant to make a note for a change. And counsel, please take a look and see if you agree. On CFJ 284, page 5, for convictions 2 and 3 of 11, would that be correct that he was on bond for conviction 3? And let me explain. I see that his arrest date above was on above meaning conviction 2 of 11. That was on August 9th of 2022. But that case was not resolved until January 13th, 2003. Therefore, it looks like he'd be on bond. Does that make sense, Mr. Saladay?
That's correct, Your Honor.
Mr. Wiggins?
I agree, Your Honor.
Mr. Champion?
I agree also.
All right, so we're just going to make a change that the defendant was on bond for conviction 3 of 11 at the time it had occurred. So what do I look at? For conviction 2 of 11, there apparently was a probation violation. Whenever there are probation violations, the court and the parties can determine if there's going to be an official violation of probation. It doesn't appear that there was an official violation for his probation, but he was given a written warning. But the court can still take that under consideration. I can also consider that for conviction 3 of 11, the defendant was on bond at the time that offense occurred. So when the defendant was convicted of an operator while intoxicated, that occurred back on November 28, 2002, and the defendant was currently on bond for another case for which he was also later on found guilty of. Next, in conviction 6 of 11, which appears on CFJ 284, pages 6 and 7, I'll note that the defendant was found to be in violation of his probation, and there was a no contest to that violation. So I now have at least 2 probation violations and 1 bond violation. Now here's another thing that I need to take a look at, and that is conviction 7 of 11 and 8 of 11. I'm sorry, 7, 8, and 9 of 11. I have said conviction 8, but that's not correct. That one was dismissed. I want to make sure Mr. Champion knows I'm tracking that. There was a nolle pros, and so that charge was dismissed. So I don't use that at all. But in conviction 7 of 11, the defendant was placed upon a period of probation to begin on September 12, 2014. That means when he committed the offense of 9 of 11, which was operating while a license was suspended, he was on probation at the time. While he did not get an official probation violation in Grand Traverse County, I can tell that he violated his probation when he committed that next offense, 9 of 11. Court also looks at driver license suspended issues. Lansing often tells courts that driver license suspended cases are somewhat irrelevant because people have a hard time paying their fines and costs, and of course they're going to continue to drive. However, the court puts some weight in them. Why? Because they tell the court that a person, when they have a conviction and have a ruling given or an instruction given to them by Lansing not to drive a car, they're more than willing to go ahead and drive the car, which means they are willing to violate rules or conditions. The court also can consider what Mr. Wiggins has argued. So now I've added some reasonable ground factors that I've discovered throughout the file myself, but I've also turned to what Mr. Wiggins argues. The fact that Mr. Minow did not make a statement to anybody prior to today about his apologies, I appreciate Mr. Minow. Having been a defense attorney, I would have told you not to say anything also, because that would be an admission until you get to a certain time. So while people like victims want to hear an apology or want to hear an acknowledgement, I want you to know I don't blame you for not doing so until the day. That was appropriate, and you have the right to remain silent. And if Mr. Champion is worth his weight, which I believe he is, he told you to remain silent. So I appreciate that. And I appreciate today that you made an apology. I can tell folks, while even an apology may not make you all feel great, it doesn't happen very often in this courtroom. But now I turn back again to the one issue that I've been hiding, not hiding, but postponing. And that is what happened to the bear, the family dog of the Olds after. When I do, I feel required to talk about the words killed, the way the offense is written. Killed or tortured is how it's charged. Thankfully, forgive me, but I want to acknowledge this very thoroughly. There's no evidence that Mr. Minow tortured the dog while Bear was alive. He did shoot the dog, which is, I know bad. I'm just saying, I want to make sure that everybody understands that I see this as the dog having been shot. The bear was not tortured during his life. But we now turn to what happened to Bear afterwards. That is quite concerning to the court. Mr. Minow decapitated the dog and cut off the dog's legs. And if I could, I cannot find any way that makes sense. The crime was done at the time the dog Bear was shot, but how the dog was treated afterwards is what shocks the senses of the court. sentence of the court is as follows. The court places the defendant upon a period of probation for 24 months, which is 6 months longer than that which was requested. The court adopts the terms or conditions of probation that are listed on CFJ 145, pages 2 and 3. I find that those are well suited for rehabilitative purposes, and for this particular case, they are well tailored. The court assesses a $68 state minimum fee, a $130 crime victim right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee, and supervision fees in the amount of $30 a month or $60 a month if there's any electronic monitoring. I assume there was no DNA order, as DNA must have been available based upon the prior felony convictions.
That's correct.
There is no restitution requested, and therefore I'll cross that line out. So the last question for the parties here, and I've gone over an extensive approach today because I understand that this case has gathered quite a bit of attention. Thankfully, I don't read a whole lot of social media other than posting pictures of my kids on dance or track and cross country. But my secretary sees it, so I know a little bit about it, but thankfully I've stayed off of it. So none of that pressure influences the court. The court is guided by the factors that I've discussed for reasonable grounds. The defendant has violated some probations in the past, and therefore a strict probationary sentence the court feels would be inadequate. And the court must then somehow try to establish some kind of sentence that fits within that guideline range. Again, how the court does that is more an art and less than a science. One moment. The sentence of the court is the defendant will serve a 60-day jail sentence with 2 days of credit. That is within the guideline range, and the court finds that nothing that the court is going to sentence the defendant will make everybody feel great. I have to balance the way the legislature gives the law to the court, and the law tells the court that I have to start off with a probationary period. Had this case gone to trial, we might be facing a different situation, but I respect and appreciate the situation. I respect and appreciate the way the case has come before the court, and I appreciate the difficulties placed upon both parties. And I think that Mr. Champion has done a great job in representing this client to get him to this stage. And the court understands that Mr. Middaugh might have some opinions to express underneath his mouth, underneath his tone, but I'm going to strongly discourage you from doing it.
Your Honor, he was just asking a question.
Okay. I appreciate it.
His employment. He was not showing any.
I appreciate it. I appreciate it. And I accept that, Mr. Champion. If you say so, then I accept your statement as an officer of the court. Mr. Champion? Mr. Middaugh, you're receiving 2 copies of one document. The first document you will place your initials on. Placing your initials neither elects nor waives any rights. By placing those initials, all you're doing is merely acknowledge a receipt of the other copy. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal, you may request the appointment of an attorney. You may do so by completing the bottom half of the copy of the document that you will take with you and return to the court within 42 days. Typically, the court does not address the gallery, but stating things here, this courtroom is a public place, and the court also wants to make sure the parties understand, including the victims, because I can speak to the victims. Nothing the court's going to do is going to bring your beloved family member back. And as I mentioned earlier, although it was kind of in passing, I have a dog. I've had pets, dogs my entire life. I grew up on a farm. So, and our dog, Hobie, sleeps on the bed next to us. So we all have very close pets, and they're like family members. Hobie's like a family member because she puts her head on my pillow and takes over my space in the bed. So I appreciate the loss that you have, and nothing I can do, but nothing I can do can make that pain go away. I have to establish a sentence that I think is governed by the law, and that's what I've done today. That's my requirement and obligation as a judge. Anything further, Mr. Saladay?
No, Your Honor.
Mr. Wiggins?
No, Your Honor.
Mr. Champion?
No, Your Honor.
Mr. Middow, I appreciate that this is a learning experience for you, and I know how difficult it is, and I appreciate that you gave an apology. Again, apologies don't always make everything feel better, but I can tell you what, if you didn't say it, there would have been people saying, well, he didn't apologize. So you made a very brave statement today. So I want to respect you as well for that. Thank you, folks. We are adjourned. You have to go with the bailiff.
Well, there you have it. I warned you. It was interesting. There was learning, and it was sad. But he gets 60 days. He gets 60 days for it, and I think the judge did a good job of explaining the constraints he's under. Not for himself so much, but so everybody knows what the situation is. And I think he went out of his way to take time with it because he knew there was interest, at least locally, in the situation, and he wanted to know why wanted everyone to know why he was doing what he was doing. I certainly don't think it was taken lightly. He had to look for justification or for good cause under the statute to even deviate from the scoring. Apparently, I don't do this. Certainly don't do it in the state of Michigan. So he had to look for justification. I think he found it. I think it was appropriate. I think the prosecutor argued it properly, and that's where we are. So I saw that and I was torn because it's like, this one is just so serious, but it's really interesting. The best I could do is give you a warning, which I did. Thank you all for coming out. I appreciate it. I'll see y'all soon.